Hey everyone, and welcome back to the channel. We're here today to break down everything that's been happening in the ongoing HYBE versus HEE JIN lawsuit, and trust me, this case just keeps getting bigger and messier with every hearing. If you didn't already know, the HYBE versus HEE JIN lawsuit isn't just a simple legal spat, it's a multi-layered dispute that spans across breach of trust allegations, shareholder rights, contract validity, and the future of Ador and newjeans. To quickly catch you up, Min was ousted as CEO of Ador, which is the HYBE subsidiary behind newjeans, and that's when everything exploded. HYBE accused Min of secretly trying to seize control of Ador by reaching out to outside investors, and they even went as far as filing a criminal complaint against her for breach of trust. But in a big twist, the police found no evidence of wrongdoing and dismissed the case. HYBE, of course, is not letting that go and is appealing the decision. On top of that, Min and HYBE are locked in a civil court battle over a put option, basically a contract clause that Min argues entitles her to around 26 billion won for her Ador shares. HYBE, on the other hand, insists that the agreement was already terminated before Min could exercise that option. And if that wasn't complicated enough, the feud has spilled into related lawsuits involving accusations about plagiarism, manipulation, newjeans contract validity, and even reputational harm, meaning this case is about way more than just money or corporate control. Now, before we really get into it, let me just make something clear. For this video, I'm using reports directly from the trial as references, and all the links will be in the description. If I get anything wrong, please correct me with the right source because this is an ongoing case, and things are changing all the time. Also, the events I'll be talking about aren't always in perfect chronological order, since the hearings themselves often jump between different issues and testimonies. And of course, I'm not a legal expert, so please don't take any of this as legal advice. I'll also be mixing in my own thoughts here and there. With that out of the way, let's get back into it. This lawsuit is messy, interconnected with other lawsuits, and honestly feels like it's spiraling into an entire K-pop industry drama on its own. So if you want to keep up with every twist and turn about newjeans, HYBE, Ador, HEE JIN, and all the lawsuits surrounding them, make sure you hit that like button and subscribe. Alright, let's dive straight in.
Get started, let's get started.
So first of all, on September 11th, HEE JIN, the former CEO of Ador and the central figure in this storm, actually appeared in court in person. This was the very first time she physically showed up since the legal battle erupted last year. The hearing took place at the Seoul Central District Court 31st Civil Agreement Division, presided over by Judge Nam In-soo. What was on the table? Two lawsuits being heard together, HYBE's case to confirm the termination of the shareholder agreement, and Min's countersuit demanding that HYBE pay her the stock purchase price from the put option. HYBE's chief legal officer, Jin-soo Jong, took the stand as a witness, and his testimony was explosive. He claimed that Min had been trying to rewrite the shareholder agreement in a way that would let her wield what he described as absolute power. He went even further, dragging HYBE's other girl group ILLIT into the case, raising suspicions of plagiarism and album manipulation. And then, Jong dropped another big allegation, saying that when newjeans members notified Ador of their intent to terminate their exclusive contracts, had a feeling that HEE JIN was behind it from beginning to end. But he didn't stop there. Jong also testified that he had received a tip about Min allegedly meeting investors in Japan. According to him, at the time, newjeans' exclusive contract injunction lawsuit was pending, and the informant showed the investor a Japanese translation of the opinion of the law firm Sejong, which former CEO Min's side said newjeans will win 100%. On top of that, Jong brought up that the prosecution ordered a supplementary investigation after the police initially dismissed HYBE's breach of trust claims. Basically, HYBE is still trying to push the criminal case further, even though Min was cleared the first time. When it was her turn to respond, Min strongly refuted Jong's statements. On the plagiarism claims regarding ILLIT, she said, "Before I personally asserted, people were talking about it in all communities, and as soon as the teaser photo came out, suspicions were raised as if, isn't this newjeans?" She dismissed the investor rumors outright, arguing, "It's just a rumor, and there's no actual contact details or such materials, right?" She also addressed the kakaotalk conversations between her and former Ador Vice President Lee Sang-woo, which HYBE had submitted as evidence. Min fired back with, "Please submit the entire conversation. It's a fictional novel, and it's almost like a soap opera. They created the story by plotting to oust me." This hearing turned into a heated back and forth. HYBE's side raised their voices, complaining, "In cross-examination, there should be a rebuttal to the witnesses' answers, but now former CEO Min is just telling his own story. Is this a press conference?" Min shot back by calling Jong's testimony lies, and even accused him directly. "You've committed a lot of perjury today. So, where does this go from here?" The court announced that they will conduct further examination of Min on November 27th, and then wrap up arguments by December 18th. A verdict is expected around the end of January next year. And remember, this particular court showdown is also the first time HYBE has gone head-to-head with Min in person since launching their audit against her back in April of last year. Interestingly, on the very same day in another courtroom of the Seoul Central District Court, another case was being heard, the one to confirm the validity of newjeans' exclusive contracts with Ador. A second attempt at mediation in that case failed, so now the court itself will have to to decide with a ruling expected next month. For now, an injunction is still in place that blocks newjeans members from pursuing independent activities without ADOR's approval. And let's circle back to the core of Min's civil case, the put option. Back in November of last year, Min formally notified HYBE that she intended to exercise it. Under that agreement, HYBE would have to buy back 75% of Min's 18% stake in ADOR, calculated based on the company's average operating profit for the 2 years prior, multiplied by 13. For context, ADOR posted a 4 billion won operating loss in 2022, but a massive turnaround in 2023, with 33.5 billion won in operating profit. Min owns 573,160 shares, or 18% of ADOR, which works out to roughly 26 billion won owed to her if the contract stands. HYBE, however, insists that her right to exercise the option expired when the shareholder agreement was terminated in July of last year. So as you can see, this isn't just one lawsuit, it's multiple lawsuits overlapping and colliding. We've got Min's stock purchase claim, HYBE's shareholder agreement termination claim, the criminal breach of trust fight, the newjeans contract case, and even side controversies like plagiarism and reputational harm accusations. It's a spiderweb of legal battles, and every new hearing seems to add more fuel to the fire. Then HYBE revealed Min Hee Jin's alleged chart manipulation plans and smear campaign evidence against ILLIT LE SSERAFIM and ILLIT, and this all came to light right as the mediation between newjeans and ADOR officially failed. On September 11, 2025, the Seoul Central District Court's 31st Civil Affairs Division heard another crucial round in the legal battle between HYBE and former ADOR CEO Min Hee Jin. According to Nate, HYBE presented evidence claiming to prove that Min orchestrated smear campaigns against ILLIT LE SSERAFIM and ILLIT, while also being involved in music chart manipulation controversies connected to both groups. This evidence was contained in a document called Project 1945. HYBE said it was first uncovered during an audit in early 2024, but resurfaced during this week's witness questioning. HYBE's chief legal officer, Young Jin-soo, testified about the document in court. According to Nate's reporting, Young was asked about the entries LE SSERAFIM 219 and ILLIT 325 that were written under a section labeled Music Chart Manipulation. He explained that these referred to LE SSERAFIM's February 19th comeback and ILLIT's March 25th debut date, and he claimed Min's team had already planned to frame both groups for digital chart manipulation even before ILLIT's official debut. More evidence came from minutes of a March 29, 2024 meeting with newjeans parents. The records included strategies like searching for employee controversy, investigating communities' SNS, and same concept photos, imitation of newjeans. Other notes read, intentionality, using unfollowing is the problem, and keeping quiet is a loss, which HYBE argued showed clear intentions to fuel negative narratives against LE SSERAFIM and ILLIT. The same document even laid out plans for how to leak stories to the press, mentioning a specific journalist and outlet with lines like, "How should I leak it to a reporter?" and "Who should I send it to?" According to HYBE, this proved there were already preparations for targeted media exposure designed to damage those groups. And all of this was happening just as newjeans' second mediation session with ADOR failed to reach any agreement on exclusive contracts. With mediation breaking down, the court confirmed it will now issue a ruling on October 30th. Meanwhile, Min Hee Jin herself attended the hearing for her separate 26 billion won, about $19.8 million USD shareholder put option lawsuit against HYBE. newjeans members did not appear at mediation. When it came to Project 1945, HYBE's legal team stressed in court that it wasn't just speculation, but a deliberate plan. They said the document was drafted on March 2, 2024, by then Vice President Lee Sang-woo under Min's direction. It listed specific tactics for pressuring HYBE's management while associating LE SSERAFIM and ILLIT with scandals. Jung Jin-soo emphasized that in ILLIT's case, framing the group as manipulative was particularly damaging since they hadn't even debuted yet. Nate reported that the March 29 meeting minutes painted the picture of a calculated, public opinion warfare strategy. That included accusations like same concept photos, imitation of newjeans to claim that LE SSERAFIM and ILLIT were copying newjeans' image. The minutes also showed an intention to escalate minor controversies into bigger scandals. For example, turning something as small as unfollowing on social media into a serious issue. The note, "Doing nothing is a loss," suggested that Min's team wanted to constantly stir up disputes rather than let issues fade. HYBE even provided alleged kakaotalk messages from Min to her team, giving real-time instructions. These included resisting plan changes, pushing negative content on April 3rd, and launching further attacks after April 11. HYBE argued this was direct proof of Min's active involvement in smear campaigns against HYBE's other artists. But Min Hee Jin flatly denied these claims. She told the court that that HYBE was misrepresenting the context of both the documents and the testimonies. She repeated her view that ILLIT's debut week sales spike seemed suspicious, and she also argued that newjeans had been consistently sidelined. On top of that, Min accused HYBE of illegally obtaining private communications, saying that much of the evidence they were presenting was collected without proper legal grounds. That same hearing also saw HYBE's CLO refuting rumors that former HYBE CEO Park Ji-won had promised newjeans a long vacation. He explained it was simply a routine break after promotions, but Min hit back immediately, accusing HYBE of lying under oath and calling their testimony fabricated. And then another angle emerged. HYBE's CLO revealed what he described as a suspicious dip in Min's behavior, interpreting it as her attempting to secure Ador's independence. In court, he said, "I have received a tip-off regarding Min HEE JIN's suspicious activities." He pointed to clauses in Ador's business agreement stating that Min HEE JIN must not engage in any actions that may cause damage to Ador or other affiliates. According to him, these clauses were included because Min HEE JIN caused many problems while working with various departments. We put these clauses in because we were concerned that these kinds of things could happen again if the company had nothing to protect her. He continued, "If someone were the head of an affiliated label, they would understand the purpose of a multi-label even without such regulations, and would make decisions to grow together. But in Min HEE JIN's case, there were many concerns that this was not the case." The CLO also discussed Min's push for renegotiation, where she claimed her contract was a slave contract. He said she demanded the put option multiple be increased from 13 to 30 times, stronger CEO authority, and sole control over signing, terminating, and extending artist contracts. He added, "If we increase it to 30x, there is a possibility that we could end up taking more money than the sales. So it's too large a number." A put option is a structure that allows you to receive compensation if you work hard and achieve good results. However, asking for a guarantee regardless of performance goes against the purpose of granting a put option. The CLO went further, saying HYBE had received a tip in February 2024 that Ador staff were reaching out to private equity funds for help with independence plans. In March, one of HYBE's major shareholders reportedly told them, "Min HEE JIN suddenly requested an exclusive meeting. I don't know why she wanted to meet, it's suspicious." He also heard that a vice president under Min had been spreading rumors that HYBE's artists were being pushed out. He testified that HYBE executives discussed all of this, especially after Min sent a negotiation proposal that far exceeded expectations. He recalled, "Min HEE JIN sent a negotiation proposal while complaining about the shareholder agreement, and the content was far beyond what we expected. But with these reports added in, I remember discussing, what are they thinking and what are they doing?" There was also the matter of an email from newjeans' parents raising plagiarism concerns. HYBE's CLO said, "We were all worried and surprised when we received this email. The plagiarism issue raised there can be subjective judgment. We thought that we could have a chance to meet and talk about whether it was plagiarism or not, and resolve the misunderstanding. However, seeing that they sent such an official email, including the artist's parents, made me feel that they were trying to cause serious problems, rather than solve them. In particular, the content mentioned a possibility of violating the exclusive contract, and we were worried that they might use this as an opportunity to shake up the artists and take them away." After that, HYBE launched a full audit of Ador and Min. Through that process, they discovered Project 1945, along with work notes, investigation documents, and even a bizarre file called HYBE's 7 Deadly Sins. On top of that, they found an email with a kakaotalk message exchanged with a shaman attached to Min's official Ador work account. Min HEE JIN, who was in court, again claimed she pushed out ILLITs to break the newjeans record. She appeared in person and stated, "ILLIT increased sales to break newjeans record." After hearing the testimony of HYBE's CLO, Chief Legal Officer, Jong Jin-soo, Min HEE JIN said, "The reason I came out today was to have a fair discussion, but when I heard there were so many lies, I thought it would have been a big problem if I hadn't come out today." On this day, Min HEE JIN pointed out that HYBE had falsely testified that they tried to resolve the issue, even though they had not lifted the ban on concurrent employment, and once again claimed that ILLIT pushed out newjeans. She explained, "If they push out even one copy, it's considered a push. The reason they say they push out is because they push the album to the distributor for the first week record. If they have to break a certain record within a week and they think they can't break that team, they say they're pushing out by hoarding." She continued, "With just one copy, you can take away someone else's #1 spot. But these 80,000 copies aren't the important number. It's because we can suspect that the team called ILLIT exploded in sales on the last day of the first week to break newjeans' record." During the same trial, HYBE's CLO alleged that Min Hee Jin met with Japanese investors who claimed newjeans would win their injunction 100%. On that same afternoon of the 11th, CLO Jong Jin-soo appeared as a witness at the final hearing of the lawsuit filed by 3 people, including former CEO Min Hee Jin, against HYBE for payment of stock purchase price related to the exercise of put options at the 31st Civil Agreement Division of the Seoul Central District Court, presiding Judge Nam In-soo, and said, Min Hee Jin met with Japanese investors. HYBE's CLO Jong said, after the allegations of plagiarism against newjeans surfaced, I met with the members' mothers and said, at the time, the mothers said they didn't care about the plagiarism and were neutral. But when Min Hee Jin showed them the photos and said, if we just sit back and do nothing, we'll be in big trouble, they changed their minds and said, should we just sit back and do nothing? Regarding CEO Park Ji-won's statement that he would give the newjeans members a vacation after their promotions, CLO Jong refuted it, saying, I never said I would give them a long vacation. The mothers might have misunderstood, but after successfully completing comeback promotions, artists go on vacation for a certain period of time. That's what I said, and I think they misunderstood it as if I was giving them a long vacation from promotions, or someone interpreted it that way. It was a place to clear up misunderstandings and build trust, so there was no reason to say anything negative. Regarding the live broadcast conducted by newjeans members last year, CLO Jong stated, I know that Min Hee Jin sent a telegram message at that time. Also, when one of the members appeared for the state audit, he was with Min Hee Jin's legal representative for nearly 4 hours the day before, and photos were taken and it was reported. He continued, there were also rumors that Min Hee Jin was meeting people to find investors. That's why I thought that Min Hee Jin was behind the exclusive contract issue for artists. He also claimed there was another separate tip. It was said that Min Hee Jin was meeting people in Japan to receive investment from Japanese investors between the end of last year and the beginning of this year. I understand that Japanese investors came to Korea and had meetings with Min Hee Jin. At the time, we were about to file for an injunction against newjeans on our exclusive contract, and they sent me a Japanese translation of the opinion of the law firm Sejong, which said, newjeans will 100% win the injunction. HYBE Entertainment also made allegations that Min Hee Jin planned a private frame before ILLIT's debut. It was revealed in court that former Ador CEO Min Hee Jin had prepared a framework for music chart manipulation and waged a public opinion war against girl groups ILLIT LE SSERAFIM and ILLIT, both affiliated with HYBE. In particular, it was revealed that secret operations had been underway even before ILLIT's debut. On the afternoon of the 11th, the 31st Civil Affairs Division of the Seoul Central District Court, presiding Judge Nam In-soo, held the 4th hearing for the confirmation of termination of shareholder agreement lawsuit filed by HYBE against former CEO Min Hee Jin and one other person. In addition, a lawsuit filed by Min Hee Jin and 2 other people against HYBE for payment due to the exercise of a put option was also held. The trial that day proceeded with the examination of witnesses from both sides. The plaintiff's witness, Jin-soo Jong, HYBE's CLO, and the defendant's witness, Hee Jin Min, appeared in court. It was previously revealed through a HYBE audit that a document titled Project 1945, written on March 2, 2024, by former Vice President Sang-woo Lee at the direction of former CEO Min, was discovered with the aim of pressuring HYBE's management and attacking the 2 groups. HYBE's legal representative presented the Project 1945 document during the plaintiff's witness examination that day and asked CLO Jin-soo Jong, what do Le Sserafim 219 and ILLIT 325, written in the music chart manipulation section, mean? CLO Jin-soo Jong stated, 219 is Le Sserafim Compact, and 325 is ILLIT's debut date. He continued, in the case of ILLIT in particular, it seems like they tried to attack with that music chart manipulation frame even before their debut. A document recording a meeting with the parents of newjeans on March 29, 2024, also revealed evidence of attacks and public opinion warfare targeting the 2 groups. The minutes of this meeting contained records such as searching for employee controversy, investigating communities HSNS, same concept photos, imitation of newjeans, intentionality using unfollowing is the problem, and keeping quiet is a loss. In addition, remarks preparing for a public opinion war were discovered, such as, how should I leak it to a reporter? And mentioning a certain reporter and a certain media outlet, Reporter U of Company M, and asking, who should I send it to? It was also revealed that former Representative Min gave instructions to Shin Dong-hoon and Lee Sang-woo via KakaoTalk on the same day after this meeting, such as, I'm pulling up the plan change. Send the first batch on April 3rd. We're preparing for a public opinion war, and send the answer and blow it up after the 11th. Min Hee Jin alleged that she submitted evidence of alleged manipulation to the court, stating, "Min will file a rebuttal in November." Former Ador CEO Min Hee Jin, who is in a legal dispute with HYBE over the exercise of a 26 billion won put option, is expected to cause repercussions as suspicions have been raised that she submitted a kakaotalk conversation suspected of being manipulated as evidence to the court hearing the case. It was confirmed that Ador's parent company, HYBE, submitted to the court another version of the kakaotalk conversation to support the incident that occurred at the trial, held at the Seoul Central District Court on the 11th. According to legal circles on the 14th, the kakaotalk transcript that HYBE submitted to the court, claiming it to be the original, contains additional sentences suspected of attempted editing on the existing screenshot with the former Ador executive that former CEO Min previously submitted as evidence. The conversation transcript submitted by HYBE specifically contains what seem to be instructions for directing, such as, "I'm going to capture this, kakaotalk, use it well," to the person he was talking to, who was an Ador executive at the time, and "It's time to act from now on, go again, erase and start again, cut to here." The specific time periods when these sentences were used in the kakaotalk conversation were also mentioned at the trial. In court that day, HYBE's side claimed that the very beginning of the existing screenshot that former CEO Min submitted to the court had the words, "I'm going to capture this, use it well." It is reported that the conversation contains the claim that a key executive at Ador last year was continuously harassed by a high-ranking executive of the parent company HYBE. It is a kakaotalk conversation that took place in January of last year, right before the internal strife between HYBE and Min Hee Jin surrounding Ador's management rights surfaced, and it appears that former CEO Min submitted this to the court as evidence that there was pressure from the parent company HYBE towards her and her close associates, and that it was the background to her resignation from the position of CEO of Ador. This trial, currently underway at the 31st Civil Agreement Division of the Seoul Central District Court, presiding Judge Nam In-soo, is a merger of a lawsuit filed by 3 people, including former CEO Min, against HYBE for the payment of stock purchase price in relation to the exercise of a put option, stock purchase right, and a lawsuit filed by HYBE against 2 people, including former CEO Min, for confirmation of termination of the shareholder agreement. Meanwhile, former CEO Min Hee Jin of Ador also sent her own statement regarding the suspicions raised in the trial that day. She informed Sports Donga, the trial on September 11, 2025, only gave Ador the opportunity to cross-examine the witnesses it requested, and most of the reported content is based on one-sided questions from Ador's legal representatives. She added, "Due to lack of time, the opportunity for cross-examination was postponed to the next trial on November 27, 2025, so I will rebut on that day, so the reported content may not be accurate or fair." In addition to raising these suspicions, the captured kakaotalk conversations appear to be a trigger that will significantly influence the outcome of numerous lawsuits surrounding former CEO Min. The battle over the slave contract, Min Hee Jin versus It Could Have Been Modified, HYBE, continued. The 31st Civil Agreement Division of the Seoul Central District Court, presiding Judge Nam In-soo, held the second hearing on the 11th in Min Hee Jin's lawsuit against HYBE seeking payment for the stock purchase related to her put option exercise. The lawsuit filed by HYBE seeking termination of the shareholder agreement was also heard simultaneously. HYBE's chief legal officer, CLO, Jin Soo-jong and Hee Jin Min appeared as witnesses. CLO Jin Soo-jong answered questions from both sides' legal representatives, and Min Hee Jin's re-examination for 4 hours and 30 minutes. Min Hee Jin's examination was not even conducted. HYBE and Min Hee Jin engaged in a fierce battle over the legality of the termination of their shareholder agreement. Issues included a non-compete clause, HYBE's album push, and Min Hee Jin's contact with investors. Min Hee Jin took issue with the non-compete clause. She reiterated her previous argument, stating, "Min Hee Jin cannot dispose of her 5% stake without HYBE's consent, and this means a permanent non-compete. It's essentially a slave contract." HYBE explained, "The intention was to prevent Min Hee Jin from selling the stock to a third party, and we met with Min Hee Jin on January 25, 2024, and explained the purpose. We were of the view that modifications were possible if she wanted," Min Hee Jin countered, calling it clear perjury. She added, "There was absolutely no positive signal regarding the request at the time of the meeting. If there had been a response offering to revise the information, the situation wouldn't have escalated to this point." HYBE explained, "At the meeting, we only talked about our demands, and since our differences of opinion could not be narrowed, we moved on to discussions between legal representatives." employees. We sent an email to Min Hee Jin's lawyer expressing our opinion that corrections were possible. Min Hee Jin's legal representative remained silent on the matter. However, Min Hee Jin remained firm in her statement, saying, "I have never seen the lawyer's email. Why did you give false testimony earlier?" Min Hee Jin also mentioned ILLIT's album Push. Its debut album sold 80,000 copies on the final day of its initial release. She claimed, "This was a last-minute hoarding to surpass newjeans' record." HYBE denied the allegations. "We've already commissioned an accounting firm to conduct a fair investigation," they said. "No label has ever engaged in any pushback." newjeans' Get Up also sold about 300,000 copies on the last day of its initial release period. Isn't that considered pushback? Min Hee Jin added the testimony of HYBE employees. She read a KakaoTalk conversation saying, "The CEO of Cause Entertainment found the initial sales of Japanese albums by not only ILLIT but also other girl groups under HYBE Entertainment to be unusual." She also mentioned a former HYBE Japan interpreter who had attended internal management meetings. "He told me that during those meetings they discussed how to handle the remaining album inventory after the push," she added. HYBE questioned the credibility of the testimony, claiming that Min Hee Jin used her position to extract favorable statements. When the company actually spoke with them, they confessed that they merely agreed with Min Hee Jin's words. The statement said, HYBE pointed out that Min Hee Jin had been meeting with investors since January of last year, including N Company, D Company, Japanese investors, and Saudi Arabian sovereign wealthy individuals. Min Hee Jin spread rumors about HYBE. Investors reported them directly. Min Hee Jin countered that the meeting with Company N was the sole action of Vice President Lee. "I only found out after the incident broke out," she argued. So the vice president personally drafted a statement confirming that former CEO Min Hee Jin had never met with investors. She continued, "I have never tried to meet with other investors before," and emphasized, "If it's true, submit evidence or call them as witnesses." Among them, the CEO of Company D contacted me first, saying he wanted tickets to the newjeans Tokyo Dome concert. HYBE stated, "There is evidence that Min Hee Jin had contact with the Saudi Arabian government," and said, "The specific content of their meeting and discussion is included in the evidence. We will submit it to the court soon." Min Hee Jin burst into laughter, saying, "It's surprising that there's evidence when we've never even met." HYBE expressed their bewilderment, saying, "Your Honor, warn Min Hee Jin not to be sarcastic." Even after the trial ended, Min Hee Jin denied meeting with the investor. "He wasn't there when I met with the CEO of Company D," she said. "I didn't even know he was coming. Then he showed up saying he was a fan of mine." The same was true for Dabalink. Min Hee Jin met with the Dabalink owner on September 30th of last year. "That's a different story," she said. "I don't know Dabalink. I want to tell you everything at the next trial." The two sides engaged in a tense war of nerves until the very end. On this day, Min Hee Jin, upon seeing Jung Jin-soo's interrogation, began by saying, "There were too many lies. If I hadn't come out today, I could have been in big trouble." HYBE interrupted Min Hee Jin as she continued to speak. "It's time for witness testimony, but you're talking about yourself like you're holding a press conference," he said. "Please refrain from making statements that are irrelevant to the issue." Min Hee Jin also raised her voice. HYBE edited and manipulated KakaoTalk messages. It's almost like they wrote a ridiculous drama on the level of writer Im Seong-hwan. HYBE confidently responded, "We will present the entire record as evidence." Finally, HYBE requested the judge, "Please look into the KakaoTalk messages between former Representative Min and former Vice Representative Lee, and you will understand why they were blocked from being presented as evidence in open court. Please determine the case accurately." Min Hee Jin notified HYBE of her intention to exercise her put option in November of last year. The calculated value is determined by multiplying Ador's average operating profit, 2022-2023, by 13 times, and then dividing by the total number of issued shares. It is estimated to be approximately KRW 26 billion, representing a 75% stake in Ador. The first hearing was held on June 13th. The two sides engaged in a heated debate over the timing of the termination of the shareholder agreement. HYBE claimed that the put option was exercised after the termination notice was given. Min Hee Jin's side argued that the termination date was the date of her departure, which occurred after that date. HYBE's side brought up the alleged tampering attempt. They emphasized Min Hee Jin planned to steal newjeans over the course of a year, and that attempt itself is grounds for contract termination. Therefore, we notified them of the contract termination on July 8th, 2024. Min Hee Jin's side countered, "I did not accept the notice at the time, and I exercised the put option first and resigned on November 20th of last year." newjeans subsequently requested termination of the contract. They argued that tampering did not occur due to the timing. Overall, there is probably more information out there about this case, but this video would go on forever, and it would become difficult to confirm whether the information is true or not, so of course do your own research. The next trial will be held on November 27th at 2 p.m., and the final hearing is scheduled for December 18th at 3 p.m. Regarding the newjeans case with Ador, the verdict in the newjeans and Ador contract dispute will be revealed on October 30th, 2025. I hope this video was helpful, and if it was, please give this video a like and subscribe if you always want to keep up with news. Thanks for watching, and I'll see you in the next video soon.